So, you might have heard about the Labor government's recent decision to scrap their proposed hate speech laws. Albanese first placed the issue on the national agenda in February 2024, with the move being driven by the government's commitment to promoting respect and understanding within Australia, especially in the face of a rise in anti Semitism and Islamophobia in the wake of the Israeli Palestinian conflict. But why did the government back down from their promised legislation? Firstly, let's make sure we understand what hate speech actually is. Hate speech refers to expressive acts that incite discrimination, hostility, or violence towards individuals or groups based on their identity or shared characteristics. However, there are vast complexities in identifying hate speech at scale, which are thought to have led to inconsistencies in law enforcement and a lack of clarity in the application of hate speech laws already existing in Australia. While Australia already has several laws aimed at combating hate speech, they seem to vary across jurisdictions. Inconsistencies within state and territory laws can create confusion and gaps in legal protection. A key federal provision against hate speech in Australia is Section 18C of the Racial Discrimination Act, which makes it unlawful to commit an act that is likely to offend, insult, humiliate, or intimidate someone based on their race, colour, or national or ethnic origin. While this provision addresses racial vilification, it has often been criticised for its lack of enforcement and limited scope, leading some minority groups to advocate for stronger anti-vilification laws. Because of these factors, there has been an increase in calls for the government to introduce more robust protections, especially for religious groups.
Of course, we must strongly support free speech and academic freedom, and that's not in question. But when speech crosses the line and it becomes incitement and hate speech and breaches university guidelines which prevent discrimination or vilification or intimidation or harassment, and when the universities are not upholding their own guidelines, we have a massive problem in this country.
Why did Australia want to implement new hate speech laws, and what was their goal? The primary goal of these new laws was to strengthen existing protections by expanding on already established offences for practising hate speech against individuals or marginalised groups. In the current polarised climate, the government wanted to draw clearer lines between legitimate democratic protest and harmful speech that incited hatred or violence. So, why didn't Australia go ahead with implementing the new laws? Ultimately, ongoing debate around freedom of expression became the key driver in blocking the proposed legislation, with concerns that expansion of hate speech laws could overly impact legitimate public discourse. Among the concerns were strong oppositions from various politicians, media organisations, legal experts, and civil liberty advocates, who argued that the proposed legislation would infringe on free speech in Australia.
And this infringement on free speech that we're seeing across the globe, as you said, the UK, Australia, you look at what these countries have done, and they've basically instituted draconian laws that are using social media as a weapon to target dissenters, to target people who don't agree with the prevailing orthodoxy that the government is spewing, and that is a problem.
Critics argued that laws like Section 18C of the Racial Discrimination Act already held restrictions over free speech by limiting an individual's ability to express opinions that might offend or insult others. They contended that in a democratic society, individuals should be free to express their beliefs without fear of being accused of discrimination or legal consequences, even if those views are unpopular or controversial. So, who does the situation benefit? And who is at a loss or disadvantage because of the situation? The decision to not implement new hate speech laws primarily benefits those concerned with protecting freedom of expression. Those who believed that the expansion of hate speech laws would lead to an impact on free speech are among those who directly gain from this situation. On the other hand, marginalised groups and vulnerable communities, including LGBTQ+ groups, Jewish communities, and other minorities, are at a disadvantage because of this decision. These groups had sought stronger legal protections against vilification and hate speech, By abandoning the plan to further outlaw vilification, their concerns remain unaddressed, leaving them more exposed to hate speech and lacking legal safeguards they were advocating for. The debate over hate speech laws in Australia highlights the ongoing challenge of balancing the right to expression with the need to protect individuals and groups from harm. While freedom of expression is acknowledged as a fundamental human right, it is not absolute in Australia and must be weighed against the rights of others to live free from hate, vilification, and threats. So, where does Australia go from here? As LGBTQ+ and Jewish communities, among others, express disappointment over the abandonment of plans to further outlaw vilification, the government insists on a careful journey towards balancing everyone's concerns. Protecting marginalised communities from hate crimes remains a priority, but so does preserving the freedoms essential to a healthy democracy. The complexities of this issue make it clear that ongoing consultation and thoughtful policy making are needed to navigate the line between protecting free speech and addressing the harm caused by hate speech.